The argument was that the exercise of power by the governor under Article 174 and 175 should also be based on aid and advice. Your Lordships were pleased to, my Lord, reject that submission. My Lord, I am not, my Lord, troubling your Lordship with that, my Lord. Lord, judgment after judgment, it is settled, my Lord. Please allow me to place Nabam Rebia, my Lord, only.
Just the para 71 and 72 also.
Yes, I'm coming to that, my Lord. 70 also, my Lord. 70, according to I'll read 70, my Lord. We are unable to accept the submission of that the observations of the Constitution bench in Nabam Rebia are arbiter. The observation in Nabam Rebia are consistent with the formulation of principle in the 9-judge bench decision in S.R. Bomai, as we have discussed earlier. Please note, my Lord, the power under Article 174 of the Constitution to summon the House and to prorogue it, but in a situation where the governor has reasons to believe that the Council of Ministers headed by the Chief Minister has lost the confidence of the House, constitutional propriety requires that the issue be resolved by calling for floor test. The governor, in calling for a floor test, cannot be construed to have acted beyond the bounds of constitutional authority. And, my Lord, loss of confidence mean in a running assembly. Now, my Lord, your Lordship may, my Lord, kindly 71. The powers which are entrusted to constitutional functionaries are not beyond the pale of judicial review. Where the exercise of discretion by the governor to call for a floor test is challenged before the court, it is not immune from judicial review. The court is entitled to determine whether, in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane. My Lord, these are the potent words used by your Lordships. It should not be irrelevant material or something completely not germane to the issue. The exercise of such power is not intended to destabilize or displace a democratically elected government accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of satisfaction by the governor is not based on extraneous considerations. So, my Lord, when there are extraneous considerations, your Lordships would step in and exercise the power of judicial review, and extraneous would mean completely irrelevant and not germane to the issue. Issue, namely, whether the governor would be justified in forming an opinion or entertaining a doubt about the government having lost the majority support. If the documents are not irrelevant or not germane, then, my Lord, perhaps your Lordships may not take a second guess on the basis as to what your Lordships would have perhaps perceived the situation to be capable of. Lord, kindly, Lord, para 73. Para 73, my Lord.
Yes.
And I have something to say, my Lord, on that no confidence, because that was not argued by any one of us, my Lord. In a situation where the House has been summoned, following the aid and advice of the Council of Ministers, the position would be more nuanced in the sense that the remedy of a no confidence motion would be available to any segment of the legislature seeking to espouse the view that the government has ceased to command the confidence of the House. When the government calls for the session being called, in exercising the constitutional authority to demand a trust vote, the governor must do so with circumspection in a manner that ensures that authority of the House to determine the existence or loss of confidence in the government is not undermined. Absent exigent and compelling circumstances, there is no reason for the governor to prevent the ordinary legislative process of no confidence motion from running its due course. Lord 74. In discharging this crucial role, it is necessary that the governor bear in mind that the purpose underlying the entrustment of the authority to require a trust vote is not to displace duly elected governments, but to intervene with caution when the circumstances which are drawn to the attention of the governor indicate a loss of majority. Circumstances should be present before the governor. This power is granted to the governor to ensure that principle of collective responsibility is maintained at all times and must be exercised with caution. The circumstances on the basis of which the governor forms a prima facie opinion leading to a communication requiring a trust vote in the legislative assembly must be of an objective nature. The decision of the governor to do so is not immune from judicial review and must therefore withstand the ability of being scrutinized on the touchstone of circumstances. Again, my lordships are careful in saying being relevant, germane, and not extraneous. I had 47 members before me saying that we don't want to support this government. We want to withdraw support from this government. That is itself an enough ground in my respectful submission. Lord, kindly, my lord, thereafter see, your lordships were pleased to, my lord, para 77 at page 1386. Your lordships were pleased to record, my lord, several past cases where the governor either decided to direct floor test, parties came here and your lordships did not intervene, or governor was not directing floor test, parties came here and when required sitting at midnight, your lordships directed that immediate floor test, and the only purpose was, I'm sorry, my lords are typing. I'm sorry,
Yes.
the object of my lord was, no, your lordships may complete. I'm sorry,
No.
that there is no time for either pressure, threat, coercion, violence, allurement, etc., etc. Whatever is the will should be reflected at the first available opportunity. Therefore, your lordships, my lord, sat at night in case of Karnataka. There are several such instances. And therefore, I am not reading, my lord, but there are large number of cases, my lord, which your lordships were pleased to reproduce. And thereafter, say at page 1389, my lord. The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. So therefore, I was saying that you should not only command the majority support at the time of formation of the government, you must continue to command that. That's the democracy. Assertion of accountability is a mirror image of collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shown a light on the often fluid allegiances of democratically elected representatives. This is a matter of their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time the trust vote is directed. All political parties are equally at risk of losing the support of their elected legislators, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both sides of the dispute congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist that would undermine a free and fair vote in assembly, the governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In circumstances as they have emerged in this case, the exercise of authority by the governor was based on circumstances which were legitimate to the purpose of ensuring that norm of collective responsibility is duly preserved. There existed no extraordinary circumstances for the governor to determine that the trust vote was not the appropriate course of action on 16th March. So it is only in extraordinary circumstances that there would be a departure from floor test rule. Otherwise, floor test is the rule. Well, that's what, my lord, the test your lordships were pleased to lay down. Because when we say, my lord, that defection is the highest political sin, Lord, running a government after losing the confidence of the electorate, namely the House, is a larger constitutional sin. to which governor should not be a party. Kindly last para 50, para 80 at page 1390.
1 minute.
This is
1 minute.
I'm sorry. Para 79, my lord, the submission that short-circuiting the speaker's power, that governor by asking for the floor test has short-circuited, my lord, the speaker's power, and your lordships are, my lord, dealing with that at para 18, 80, my lord, 80. It is trite law that neither the governor nor for that matter this court has the power to impinge upon the authority of the speaker to take a decision on the above issues. The issue, however, is whether the convening of a trust vote has to be deferred until such time as the speaker has taken a decision on whether or not to accept the resignation, and if so, the consequence of the members departing from the fold of the party on whose ticket they were elected under the 10th schedule. Holding of a trust vote operates in a distinct field from the issue as to whether one or more individual members of the Legislative Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of 10th schedule. Holding a trust vote is necessary to ascertain whether the Council of Ministers headed by the Chief Minister has the confidence of the House. The continuous existence of that confidence is crucial to the legitimacy and hence survival of the government. I could never have put it, my lord, like this. Continuous existence of that trust gives you the legitimacy in democracy. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have the faith of the legislative body as a collective entity